Good afternoon, everybody. This is Dustin Peterson, and I am the OklahomaCityAttorney.com. Today, we're going to be talking about joint tenancy in home ownership in a marriage and what happens to that home in divorce. This is continuing on our discussion of equitable property distribution. So here's the situation. The married couple have joint tenancy of a home, and this was affected when the husband, let's say, purchased the house prior to marriage, but then when the parties were married, the wife was added to a new deed to the home. And that created, through the four unities, you may know possession, interest, title, and time, of joint tenancy in the house. That's crucial for marriage because, say, if a creditor were to come after the assets of one spouse, in joint tenancy, they couldn't get the house because the other spouse also owns all of the house, 100% of the house, so they couldn't take it. So how does this work, though, in divorce if the husband wanted to divorce the wife, having purchased the house with his separate funds prior to the marriage and is claiming the house as separate property? Well, because the wife never contributed to the purchase price of the house, the husband's going to say, well, the source of funds is going to apply here, and I should get all of the house because I paid for it. That's not the way the courts are going to treat that, because there is a presumption that when he added his wife to a new deed to create the joint tenancy, that there is a presumption that he gifted a portion of this house, or all of this house, ownership of all of this house, to the wife. So that is how the wife would try to get her share of the marital property. And if you have any questions about joint tenancy in marriage and who gets the house, don't hesitate to call me, 405-888-5400, or look me up online at theOklahomaCityAttorney.com.